So here we will be having two subjects, I mean two books, BARE Acts basically for criminal procedure. One is CRPC and BNSS. Both are almost, except section numbers, content will be similar. Okay, there are some changes in the sections. Some sections are removed and couple of things are added in BNSS. Couple of old sections are removed. Okay, the main reason is BNSS is latest, so all absolute sections which are not used, which are not relevant in present this thing. So in criminal procedure and IPC, that is BNS, these two things are criminal acts. In these two things, and along with that, evidence is also part of criminal act, because a lot of things in criminal crime we take evidence. Okay, all these three they have come out with new acts, that is BNS for IPC, BNSS for CRPC, and Bharatiya Sakshi Adhiniyam BSA for Evidence Act. Okay, these three are new acts. So I'll just show you question paper of 2024, that is AIBE 19. Okay, so you'll understand what type of questions they are asking. But in AIBE 19, even though syllabus says CRPC and BNSS, almost every question is from BNSS only. Okay, so let me share the screen. Are you able to see the screen?
Yeah.
Yes.
So here, normally in most cases, see, I cannot say it will happen in future, but in most cases here from 1 to 10, set C, set A, set B, set C, set D, there will be different type of paper which will be given to students. So in set A, I'm talking about this is set A. So all the questions from 1 to 10 are from Constitution. Okay. 11 to 18, there are 8 questions from IPC. Okay. So from 19, that is BNSS. 10 questions will be there from BNSS. 8 questions from evidence. Okay. So from 19 to 28, it will be in one place only. So you can just take away once you identify question paper that you are going to start answering BNSS, you can just pull out your BNSS and CRPC books. You can keep them aside. So it will be easy for you to refer. Like last time what I told, index is very important. So you can answer a few questions from index itself. And if there is any specific section which you have to refer the BARE Act, you can go using the index, go to that specific page number. You can open that and read it and answer accordingly. Okay, so here it is, see, you get some concept based questions, you get case law also, very few, but most of the time, say, let us say out of 10, 7 to 9 will be from BARE Act only. 7 to 9 questions. Sometimes I just giving a range because it can be 9 or 10 also from BARE Act directly. But most of the time it will be from BARE Act, except 1 or 2 questions. They ask you should have some basic understanding of the concepts. So I'll make you understand about the concepts, introduction, all those things. Here, consider the following statement and answer given below. So this is concept-based question. Okay. So whether he can arrest with warrant or without warrant, whatever it is. See here, in most of the time, you can find out BNSS and BSA. They will give the BARE Act name also in the question most of the time. Okay, BNSS introduced the provision of registration of FIR relating to commission of cognizable offence irrespective of area the offence is committed. The FIR is known. Okay, here it is concept based. You cannot find it. Will be difficult for you to look section wise. It will be there in the BARE Act, but here it is concept based. Okay, so of course it is very easy question. BNSS introduced the provision of registration of FIR relating to commission of cognizable offence irrespective of area where the offence is committed. So that is zero FIR. So you can lodge your complaint in any of the police station nearby. You need not go to the local police station. See, normally earlier when CRPC was there, so you had to go and give a complaint in only local police station. There was other outside jurisdiction police were not taking the complaints. So it was a bigger challenge, because if you are from outstation or it is an emergency, then it will be a big difficulty. So they have introduced this zero FIR in BNSS. So with BNSS, you can go and lodge a complaint in any of the police station available anywhere in the country. So they will direct it to the correct police station. Okay, so this is more of concept based. If you want to search in the Bail Act, it will be very difficult to search such questions. Okay, again, the BNSS mandates forensic team to visit the crime scene to collect the evidence for offences punishable with imprisonment for at least dash years. Okay, forensic teams. This is BNSS forensic teams. Okay, you can. That's what I told. You have to understand about the headings index. Also, you should be aware. So 2 years, 4 years, 7 years, and 5 years for which crime forensic visit is mandatory. Collection of that one. Okay. Which section of BNSS allow trial in absentia of proclaimed offenders? So this is here. This is section based question. So here you can go to index. You can search in BNSS 251. What is 251? What is 349? What 356 says and what 366 says. Okay, here already it is strict. So I'll go into 256 in the Bail Act itself. Trials in absentia of proclaimed offenders. So 356 says inquiry, trial or judgment in absentia of proclaimed offender. Okay, so it is straight away in the index itself. You can find answer for this one. Then 366, let us say what you will find in 366. It is court to be open. Nothing to do with court to be open. 349. Powers of magistrate to order to give specimen signature. Now it is not 351, 251. So 251 says framing of charge. So it is very easy. You just go to the index, you can search. It will take less than half minute to answer this question, because just go to 251, then go to 349, then go to 356. In BNS Act, it is direct question from the index itself. Which section of BNSS facilitates trial and proceedings to be held in electronic mode? So here again, you can go to 532, 530, 330, 430. Straight away you can see, since it is answer is that, I'll just check 530 directly. If we, from the index itself, you can find 530 trial and proceedings to be held in electronic mode. Straight away you can see 530 it is there. 430 you for cross checking, because you go in order. 430 says suspension of sentence pending appeal. So no. 330. Okay. So 330 says no formal proof of certain documents. No. So 430 also. So you just see the index. You can answer at least 5 questions from the index itself of BNSS. Okay. You need not go into the book. You need not understand the concept. 5 answers you can answer directly from the index itself. Which section of BNSS repeals Code of Criminal Procedure 1973? Which section repeals? So there are sections given: 531, 101, 2 or 1. So normally it will be first or last. Okay, it will be generally repealing will be in the ending actually. So you can go to the last. Repeal and savings 531. So straight away first question itself you can answer Bail Act. From the Bail Act itself 531. The last section in the Bail Act, that is repeal and saving, is that one. So repeal the Code of Criminal Procedure, that is 531. 101 generally it will be the normal repealing will be in the beginning or ending. Introduction and repealing. Repealing mostly it will be in end only. Okay. So repeal and saving is section 531. So similarly, all the sections, see here again, which section mandates government to notify? 98, 198, 298, 398. Just see the index and you can answer. Which section mandates appointment of designated police officer? 25 section, 35 section, 37, 45. So which section introduce provision, identify, attaching? Straight away section question is asked. Which section places restrictions on adjournment? It is again section based. Just you can answer on from index 6 questions, which will take less than 2 minutes. For 6 questions, it will take just 2 minutes. And other questions you need to search. And the concept based like zero FRA, you should learn some basic concepts. So that is the reason I told you should read civil procedure, criminal procedure, constitution, and contract, your graduation textbooks. Okay, so graduation textbooks you contain it contains some concept based answers. Okay, you will understand what is warrant, what is summons. So if there is some question related to summons, like what we have seen here, 19. So arrest. So this is more like a concept based question. Consider the following statement and answer the question given below. Mr. Patel, being a police officer, receives a complaint and information that Raju was involved in a robbery of bank and also has helped to hide the valuable properties in his farm, as stated by 2 villagers. With this regard, consider the following. The police officer, Mr. Patel, may arrest Raju without warrant. So these are the options. Raju can be arrested only if commits a non-cognizable offense in the presence of, okay, since reasonable complaint against Raju has been received and there is a strong suspicion exists due to testimony of villagers, he can be immediately arrested. Raju can be arrested only when he tries to escape or run away. Raju can be arrested so to prevent him from making an inducement, threat or promise to any person acquainted with facts and circumstances. So here 1 and 3, 2 and 4, only 4, only 2, they have given options. So you have to choose. Here it is, if you understand the concept of arrest, warrant, all those things, cognizable, non-cognizable, then it will be easy to answer such questions. So concepts are also important to certain extent. See, what we are not talking of scoring 45 marks. We are talking about scoring 80, 85, 90 marks or more than 70%. So you should understand the concepts better. If you don't understand concept, just by bare acts also you can answer 6 to 7 questions from CRPC and BNSS. Okay. So here, this is just, I want to show the question paper in 2024. AIBE 19 question paper, all questions are from BNSS. But same time, don't expect that it will be repeated in 20 also, AIBE 20 also. They may ask from CRPC because CRPC is also in syllabus. They may ask. Okay, BNSS, it was the first time they introduced in syllabus, so every question was from BNSS. None of the questions was from CRPC. So you have to carry both the books. So whoever purchased the books of 25, the set for BNS, I mean BNS and CRPC are included in that set. Okay. So this is about question papers, what type of questions you can expect. Okay. So I'll show you chapter wise list. I'll share the PDF also later. For your benefit, I want to share so that it will be easy for you to understand how this looks. So criminal procedure code, you can call BNSS. Chapters are almost similar in both the things. Some sections will be changed, but I have made it from CRPC. So in BNSS, you find a table where there is a comparison of CRPC and BNSS are given. So anywhere you just open that first couple of pages, you will find the comparison. 75 section, what is it in BNSS? 77 in what is it in BNSS? I mean 77 of CRPC, 85 of CRPC. What is that? So you can find it in the BNSS Bare Act. There is a comparative table is there in the beginning itself. Okay, so there are chapters are similar, sections are changed. Okay, the reason I gave the index of constitution and I'm talking about CRPC also, it will be easy for you to understand. Okay, so it starts preliminary, constitution of criminal courts and officers. I'll talk about constitution of criminal courts and officers today. Powers of courts, we will talk about it. Provisions relating to administration of justice. Okay, so provisions relating to administration of justice, normally, very rarely they have asked this question. Okay, so they may ask, they may not ask, but only arrest is important. So they will ask about the arrest of the person. Okay, so then information Chapter 5 is important. Arrest of person. Here, powers of superior officer is not important. Arrest of person is important. Here, very important. You may expect some questions. Process to compel appearances. Here, 61 to 90. Process to compel appearances. Here you have summons, you have warrants also, and proclamation also. Three important topics are there where you need to understand the concepts also. So this is very important. Chapter 6 is very important. Mostly you will have one question from chapter 6. Okay. Because you have summons in that one, you have warrant in that one, you are having proclamation. Okay. So they may ask any question from one of the three, warrant, and they may ask even two also from this chapter 6. Okay. Then chapter 7, process to compel production of things. Very rarely they ask. Okay, 7A, reciprocal arrangements of assets. No, I think I don't know about this. They may not ask about this also. Earlier, I think they have made now 7A, they have made the new chapter actually in BNSS. They have made it into chapter 8 actually. Okay, here this is CRPC. In BNSS, they have made reciprocal arrangements as a chapter 8. So you have to just remember that one. Order is almost similar. Security for keeping the peace and for good behavior is also not so important. You keep in mind, so which are important, which are not important. Then order for maintenance of wives and children, sometimes they must, but you may ignore. Okay. I mean, you have to, for this such questions, when I am saying not important, you may, questions will be asked from bare act, not from the concept. Okay. When I am talking of important, it is concepts. Warrant is a concept, summons is a concept, session court is a concept. I mean, what we used to call metropolitan magistrate or judicial magistrate, what we are calling after BNSS, magistrate is the important concept. So those things you have to understand. But here, other sections, when I am saying it is not important, you may get questions, but you can answer those questions from the bare acts. From index itself, you can answer. Okay, maintenance of public order and tranquility also, you can answer from the bare act only. Then information to police. Okay, so and their power to investigate is also, you can so this is chapter 11, 1 minute. Okay, preventive action of police. So there are some concept based things. Just you go through that one once, for 149 section to 153 of CRPC and related sections in so 168 to 172 in BNSS. Okay. So I opened the CRPC also. That is the reason it took some time for me, because I'm holding BNSS book in my hand. Okay. Then information to police, you will get compulsory question. Okay. The main reason information to police is important because here it is starting from sections 154 and 160, 170, 154 to the actual trial in criminal procedure, FIR, arrest. They may go before, but it is the main procedure of trial is started from 154. All earlier things are about powers, all those things. But real court practice starts from chapter 12. Okay. It starts from chapter 12, real court practices. I'll talk about that next slide. I'll show you that what exactly is the trial procedure. Then we'll go step by step for other things. Okay. Then proceedings in prosecution. This is also what we say in trial process. Okay. Jurisdiction is important. Okay, you will get zero FIR is from jurisdiction only. You got it. When we are talking about zero FIR, if you are aware of the sections, you can go and search in this one. But I think nowhere they mention about specific word. Zero FIR is not used in BNSS. I'm not sure about it, but it is more of a concept. So jurisdiction is removed now. You can go and give a complaint. See, jurisdiction for the courts, but for the complaint, it is different. Okay. Conditions requisite for initiation of proceedings. This is also important chapter. You will get questions. Initiation of proceedings is important. You may get compulsory question. Then complaints is important. Concepts are there. Then commencement of procedure. See, all these things related to trial. Okay, the charge, the trial of warrant cases, trial of summons cases, summary trials. Okay, then even plea bargaining. Okay, plea bargaining. I think okay. I didn't. I was searching for some other question paper. I saw that question in plea bargaining in 2022 paper. I think. In 17, yeah, AIBE 17, there is a question from plea bargaining. So you try to answer previous year questions. That is also important. Okay. Then attendance of persons, you can answer from index itself, and all other things hereafter. It is more of index based questions. Okay. So why I'm giving, I'll be sharing these things to you in the group. But the main purpose of index is you will understand. Okay. So then there are schedules also where you get question about there are two schedules in the group. But the main purpose of index is you will understand. So okay. Here, so we will be having. Then there are schedules also. I mean, you get books basically for about there are two schedules. Criminal procedure. Two in the ending. One is CRPC and BNSS. Both are almost another important thing. Except section numbers get confused. I may use IPC instead of there are some changes in the BNS. Some sections are removed and couple of you can added and use both words simultaneously. Couple of old sections are removed. So IPC, the main reason CRPC are very closely related. Is latest. CRPC, so all absolute sections actually are not used, which are not relevant in crime is investigated. So and how in criminal procedure and IPC, that is BNS, okay, then these two IPC things are criminal acts. What the crime is, things, what the sections are, with that evidence is also part of. What is the punishment? Because lot of things in criminal based on the punishment, we take evidence. Okay, jury, I mean, court will be different. So first class magistrate, sessions court, that is BNS, judicial magistrate for IPC, BNSS. Okay, there are three for CRPC now actually, and bar first class BSA magistrate, judicial magistrate. Okay, these three are new acts. Okay, so, both are same. I'll chief judicial magistrate is also first class magistrate only, but there are little bit extra powers for chief judicial magistrate. That is don't get confused. 19. Chief judicial magistrate, so you will understand, and magistrate. Both are there. What type of questions they are asking. First class magistrate. In AIBE 19, now even though I don't know about other states, but in Andhra Pradesh and Telangana, we don't have second class magistrate. Almost every question is books, you may have second class magistrates under different types of courts. But okay, in theory you have. Share the screen. In practice, in courts, you don't have second class magistrate in Telangana and Andhra Pradesh because the entry level post is junior civil judge and first class magistrate. Okay, first class junior civil judge and first class magistrate they call it. So straight away they are becoming junior JCJs and they are equivalent to first class magistrates only. So there is no second class magistrates. Earlier there was second class magistrate maybe 40 years back. Screen? But since my knowledge goes, I didn't see any second class magistrate in AP and Telangana. Okay, so here so normally talk about first class magistrates only in real happen in trial, but in sessions practice cases in real trial. Here from 1 to all 10, courts, there is no original jurisdiction for criminal set A, set B, set trial in High Court. There will be 4 different type of High Court is only appellate given to students. Court. So in set A, I am talking about this in set A. First class magistrate. So all the questions try the from 1 to 10 are from Constitution. Okay, so all the cases 18, there are 8 under what section the crime is committed. IPC. What is the crime? Okay, is defined in IPC. From 19, that is BNSS. And 10 questions will procedure from to be BNSS. Followed for the crime is defined in 8 questions from evidence. How it is to be investigated, how it is to be tried, from 19 to 28. So it is in. It will be in one place only. That is very important. Why just take away once you identify interlinked paper and evidence is that based on you are going to start answering BNSS. Go ahead and just pull out your BNSS and CRPC. So let us say them aside. So it will be easy for you to refer. Like last time what I told. So murder is IPC section 302. Index is very important. So
okay, how
you
it should
can
be tried.
answer a few questions from index itself.
There will be
And if there is any
formal
specific
complaint or
section
something
which you
is,
have to refer the
given
Bayer Act,
to
you can go
police.
using the index, you go to the
Police
specific
then
page
files an
number.
FIR.
You can
Directly they can file an FIR.
open that and read it
Okay.
and answer
Then
accordingly.
they will arrest.
Okay.
Then
so here it is.
he will
see, you
produce
get
in
some
front of first class
concept-based questions,
magistrate
you
only.
get case law also.
First
Very
class
few,
magistrate,
but most
based
of the
on the
time, say, let us
sections,
say
whether
out of
it
10,
is more than 7 years,
7 to 9
or
will be
less than
from,
7 years, depending on his
Bayer Act
jurisdiction,
only. 7 to
he
9
will
questions.
commit that
Sometimes,
case to
just giving a range.
different court. So
Because
since
it
it
can
is a
be
murder,
9 or 10 also
because
from Bayer
he
Act
cannot
directly. But
punish
most of the time, it will be from
more than 7 years.
Bayer Act.
He will
Except
transfer
one
the
or two
case to
questions
Sessions
they
Court,
ask,
where it
you
is
should
life
have some
imprisonment,
basic understanding
penalty,
of the
anything
concept.
they will,
So,
the Sessions Court can impose.
I'll make you understand
Okay.
about the
So
concept
that
introduction
case
of
will
those
be
things.
transferred to Session Court
Here,
from Magistrate
consider
Court
the following
only.
statement and answer given
Okay.
below.
It will be transferred from Sessions
So
Court.
this is
So from
concept-based
Magistrate.
question.
All cases are brought in
Okay.
front of Magistrate only, based
So
on
whether
the
he can arrest with warrant or
right
without warrant,
section,
whatever it is.
then he will transfer it to the consent court. It will
See
go
here
to the
in most
specific sessions are
most of the time
see,
you can
chief
find
judicial
out
magistrate, or
BNSS
he will
and
judicial
PSA,
magistrate
they will
himself, he
give
may
the
do the trial.
Bayer Act name
Okay.
also in
So
the question most of
this
the
is
time.
very important. In some
Okay.
places,
BNSS introduced the
there is no
provision of
judicial
registration of
magistrate.
FIR
There is
relating
only
to
chief judicial magistrate.
commission
Let
of
us take
cognizable
in,
offence
I'll
irrespective
talk about
of
Secretariat
area
Court only.
the offence is
Secretariat
committed.
Court,
The
there is no
FIR
chief
is
judicial,
known.
there is no judicial
Okay.
magistrate.
Here
There are
it is
chief
concept
judicial
based, you
magistrates
cannot
only.
find it. Will
So
be
even
difficult
check
for
bounces
you
cases are
look
tried by chief judicial
section
magistrate.
wise. It will be there in the
But when you go to some other places,
here it is
there is some
concept based.
judicial magistrate courts are also there.
Okay.
Like
So,
Manoranjan court is
of
there.
course, it is
Exclusively
very
they
easy question.
try smaller cases only.
BNSS
all check bounces
introduced the provision of
registration
registration of
it is not
FIR
under,
relating to
Secretariat
commission of
police station
cognizable offence
when it is tried in
irrespective of
Hyderabad police
area
station
where
limits,
the offence
it
is
is judicial
committed.
magistrate, not chief
So,
judicial magistrate.
That is zero FIR. So
Okay.
you can lodge your
Depending on the
complaint
court,
in
if
any
there
of
is no
the
judicial magistrate,
the case
police
may be
station
tried by
nearby, you
chief
need not
judicial
go to the
magistrate, but
local
it
police
will not be
station.
tried by
Normally,
Sessions Court. Earlier when
okay,
CRPC
chief
was
judicial
there,
magistrate
so
and
you have to
judicial
go and
magistrate
give a
will may try
complaint
the
in only
similar
local
cases.
police station.
But Sessions
There
Court,
was
Sessions trial is
other
totally different.
outside jurisdiction police were not taking
Okay.
the complaints.
Are you able
So
to
it was
understand?
a
I'm
bigger
going fast.
challenge because if you are from outstation or it is an
Yeah, it's
emergency,
clear.
then it will be a big difficulty.
Okay.
So they have
So,
introduced this zero
You are
FIR
having books,
in
you can
BNSS.
open that book.
So with BNSS, you can go and lodge a complaint in any of
Actually,
the
I think I took a
police station
session for
available
regular.
anywhere
I'll
in
share
the
that
country.
PDF.
So they will
presentation of CRPC
direct it
also
to
to
the
you.
correct police
Okay.
station.
So,
Okay.
first thing is,
So
this is
you have to
more of
understand the
concept
definition. If you want
definitions.
to search in the Bayer Act,
Okay.
it will be very difficult to search such questions. I'm just
Okay.
opening the
Again,
book. The BNSS mandates forensic team to visit the
not
crime scene to collect
Bayer Act.
evidence for offences punishable
Okay.
with imprisonment for at least -years. Okay, forensic teams. This
So,
is
section 1
BNSS
talks
forensic
about
teams.
short title,
Okay,
extent
you
and
can,
commencement. That's
you
what I
ignore
told.
that one. You have to understand
Then
about the headings. Index
Section
also
2
you should
talks
be
about
aware.
different
So,
definitions.
2 years, 4 years,
A lot
7
of
years, and 5 years.
definitions
For
are there.
which crime?
Here in BNSS, I'm
forensic
talking
visit
audio,
is
video,
mandatory.
electronic means.
Collection of that.
Bail. This is not there
Okay.
in
Which section of BNSS allowed
CRPC?
trial in absentia
Audio,
of
video,
proclaimed
electronic
offenders?
means
So
section
this is,
2.
here this is section based question. So
is not
there
there
you can
in,
go to index. You can search in BNSS
what is
251, what is 251, what is 349, what
BNSS.
366
Okay,
says,
it
and
was-
what 366 says.
It starts
Okay.
from
Here already it is
bailable
so I
offence.
just I'll go
Okay,
into
definition
256
started from
in the
bailable
Bayer Act
offence.
itself.
That is section 2.
Trails
A is bailable offence.
absentia
Here
of
section
proclaimed
2A
offenders.
is audio, video,
So
electronic means.
356 says
B is
inquiry, trial or
C is
judgment
bailable
in
offence.
absentia of proclaimed
Okay.
offender.
So,
Okay. So
again,
it is straight
then
away in the index.
bail
itself,
bond
you
is
can find
there,
answer for this
bond
one.
is there,
Then
all those things are there as
BNSS,
what you will find
those
in
things are
366.
not there in CRPC.
It is court
Okay,
to
those
be open.
definitions are
Nothing
not there
to do
in
with
court to be open.
this thing.
349.
You can
Powers
read
of
those
magistrate to
definitions
order to give specific
from the
signature. No,
Bayer
it
Act
is not
itself.
to 350,
Because if they ask
251.
any question from the
So, 251 says
Bayer Act, you can straight away where it is
framing of
where
charge.
you can find
so
bail
it is
under
very easy.
section.
You just
Okay.
go to the index, you can search. It will take less than half minute
Straight
to
away
answer this question.
BNSS
Just go to
because,
251,
bail is not
then go to
defined in,
349, then go to 350
CRPC.
in BNS Act. It is direct question from the index itself.
So you should be
Which section
but normally
of BNSS
gives,
facilities
like
trial
what
and
we have
proceedings
seen
to be held
BNSS
in electronic mode.
So here again,
CRPC, he will
you
use
can
the
go
word.
to
So
532,
accordingly,
you can search.
530, 330, 430. Straight away you can see. Since it is answer is that I'll just check 530 directly. If we, from the index itself, you can find 530 trial and
So there are a
proceedings
lot
to be
of
held in electronic
definitions
mode. Straight
which
away
are
you can see
important.
530 it is there.
So
430 you for
bailable
prosecuting
offense,
because you go in order. 430
cognizable offense,
suspension of sentence pending
okay,
appeal.
non-cognizable
So,
offense.
330.
So these
Okay.
are all
So,
important concepts. Okay. So what is bailable offense?
330 says
There is a schedule. Okay.
no formal proof of
So
certain
bailable
documents.
offense means
No.
an offense
So
which is
430
shown
also.
as
So
bailable
you
in the
just
first
see the
schedule.
index. You can answer.
Okay,
If
first,
five
as I
questions
told,
from the index
there is a
itself
schedule at the
of
end.
BNSS.
So
Okay,
bailable
you need
offense
not go
means
into the
any
book,
offense
you need
which
not
is shown
understand the
as
concept.
bailable in the first
Answers
schedule
you
of
can,
which is
answer
made
directly
bailable for
from
any
the
law
index itself.
for the time
Which
in
section
force,
of
and
BNSS
non-bailable
repeals
offense means
Code
any
of Criminal
other offense.
Procedure
So
1973.
there is no
Which section
clarity here.
repeals?
So there are
Whatever
sections given.
is there in
531, 101,
bailable
2 or 1. All
So
other
normally
offenses
it
are
will be first or
non-bailable.
last. Okay, it will be generally repealing will be
Okay.
the ending actually.
So you can go to the
Non-bailable
last
means
repeal and say
when we are talking about bailable
bailable
offense,
question itself, you can answer Bail Act
it
from the
is-
Bail Act itself. 531.
he is having
the
the
last
right,
section
bail is
in
the
the
right.
Bail Act. That is
Okay,
repeal
by
and saving
default,
is that
he
one.
is,
So
he can
repeal
get
the
a
Code of
bail.
Criminal Procedure. That is
Police
531.
themselves can
101
give a
generally,
bail, station bail can be
normal
given.
repealing will
If
be
it
the
is a
beginning or ending. Introduction
bailable
and repeal.
offense.
Repealing mostly
As
it will be
simple as
like
that.
that only.
If it
Okay.
is
So
non-bailable
repeal and
offense,
saving is section 531.
he has to file.
So similarly,
all the sections.
See here again, which section
Petition
mandates
in
the
the court.
government to notify? 98,
Okay.
198,
For
298.
bail.
Just
Once
see the
he is
index and
arrested,
you
he
can
will be
answer.
arrested. Then he
Which
will be
section
produced
mandates
in the
appointment
court.
of
Then he has to
designated
file a
police
petition
officer?
for the
25
bail.
section, 35 section,
Then
37,
court may
45.
direct to
So
produce
which
the
section
sureties,
introduce
bonds,
provision
whatever is
identified
required.
attaching?
So
Straight away
accordingly,
section
then
question is
bail
asked.
is granted
Which
or
section
bail may
places
be rejected.
restrictions on
So
adjournment?
in
It is
non-bailable
cases,
cases,
you can
bail is
answer
not a right.
on from index.
You can
6
get a
questions,
bail,
which
but
will
it is
take
not
less
a
than
right.
2 minutes.
Not
For
default.
6 questions, it will take
Okay,
just 2
bailable
minutes.
offense, it is
And
a
other questions
right.
you need to solve.
Police
And
themselves
the
can
concept
give
is
the
like zero for
non-bailable offense.
learn some
You have to
basic
go to the
concept.
court,
So that is the reason I told
file a bail
should,
petition,
read.
then you will be
Civil
getting
procedure,
court will give you
criminal
the bail
procedure,
depending on the
constitution,
merits of the
and
case.
contract.
Case to case,
Your
based on the
graduation
merits, they will give, they will reject.
Okay.
They may give for the
So
second time, then
graduating
you may go to
textbooks
higher court,
contain,
sessions court, then you
it
can go to
contains,
high court, supreme court. For the bail, you
some,
can go accordingly.
concept-based answers. Okay, you will understand what
Bailable
is
offense
warrant, what is
from the
summons.
station.
So
Non-bailable
if
offense,
there
you
is
have to
some
go to the
question
court. It
related
is not
to
your
summons,
right to get
like
the bail.
what we
This
have
is very
seen
important.
here,
You have to understand
19.
the concept.
So
Okay.
arrest.
So
This
then
is
same
more
time,
like a concept-based
cognizable offense.
Consider the
another
following
important
statement
thing.
and answer the
Cognizable
question
offense
given
means
below.
any
Mr. Patel, being
case
a
where
police officer receives a complaint and information
can
that
arrest
Raju
without
was
a
involved
warrant.
in a robbery of bank
Simple.
and also
Cognizable
has helped
offense.
to hide the
See,
valuable
it is for
properties in
it
his
is
farm.
to understand
as
the
stated by
powers
two
of
villagers.
police.
With this
Okay,
regard,
here,
consider the following.
bailable, non-bailable,
The police
cognizable,
officer,
non-cognizable,
Mr. Patel,
is
may
to
arrest
understand
Raju
the
without
powers
warrant.
of court and the powers
So
of the
these
police.
are the options.
So
Raju
in
can
case
be
of
arrested only if
cognizable
he commits
offense,
a
the
non-cognizable
police
offense in the
officer
presence of
can straight away
since
go
cognizable
and
reasonable
arrest
complaint against Raju has
person
been
without
received
any
and there is a
warrant.
strong suspicion.
So if it is
exists
a
due to
non-cognizable
testimony of
offense,
villagers, he can
police
be
cannot
immediately
arrest
arrested.
the person
Raju
without
can
any
be
warrant.
arrested
They have to
only
get
when
a
he tries
warrant
to escape or run
So
away.
they have to
Raju
go
can
to
be
the
arrested
court.
so to
They
prevent
have
him
to
from
take a
making an
warrant,
inducement,
go and
threat or
arrest that
promise
person if
to
it is a
any person
non-cognizable crime.
acquainted with facts and circumstances.
If it
So
is a
here, 193,
cognizable,
2 and
he
4,
will
only
can
4,
go
only
and
2,
arrest the
they
person
have
without
given
any warrant.
options.
This is the main
So you have
concept.
to choose. Here it
Okay.
is. If
So
you
again,
understand
it is given
the
in the
concept
schedule
of
one,
arrest, warrant,
first
all
schedule,
those things,
what are cognizable,
what are
non-cognizable offenses,
then it will be easy to answer
list
such
is
questions.
given.
So concepts are also important.
So
to
basically,
certain
this is the
extent.
only
What we are talking, we are not talking of
different.
scoring
Cognizable
45
police
marks.
can
We are
arrest
talking
directly.
about scoring 80, 85, 90
Non-cognizable
marks.
police
More than 70%.
cannot arrest without a warrant.
So you should
Okay.
understand the
Then
concepts
same
better. If you
bailable
don't
offense,
understand
where
concepts, just
bail is
by
the right,
Bail Acts also you can answer
non-bailable,
6 to
bail
7
is not a
questions
right.
from
He has to go to the court to get the bail.
CRPC and BNSS. Okay. So
And
here,
cognizable
this is
offenses,
just I
I
want to
need
show
not
the
go-
question paper.
It is some
In
serious crime
to
where the
2024,
punishment is higher, more than 3 years normally.
AIBE
Okay.
19 question paper,
Non-cognizable
all
offense is less than 3
questions
years
are
punishment.
from BNSS.
So those are all
But same time, don't expect
concept
that
based.
it
So
will
you
repeat
can
in, it will be
you
repeated
get
in
you don't get mostly
20 also, AIBE 20
I
also.
just have to
They
see.
may ask from CRPC because CRPC is also in syllabus. They may
Okay,
ask.
so in the
Okay,
Bail Act
BNSS,
also you don't
it
find
was the
that
first
3
time
years
they
punishment
introduced in syllabus,
cognizable
so
offense
every
more than 3 years
was from BNSS. None of the
it is
questions
in the
was from
textbooks. In
CRPC.
your your LLB textbook, you will
So
find.
you have
they
to carry
you may
both
get
the
question.
books. What is
So
the
whoever purchased
minimum
that
imprisonment for
25,
cognizable
that's
crime?
it.
So for 3 years and
For
above,
BNS,
are cognizable crime.
BNS and CRPC are
Okay.
included in that
So
set.
in Bail Act, it is not
Okay.
there. In the definition,
So-
just I was going through that cognizable offense. So they didn't mention that 3 years is not mentioned. Cognizable means any
this
offense
is
which
about question
I
papers,
mean,
what type of
a
questions
police
you can
officer may,
expect.
in accordance with the first schedule
Okay.
or order, so may or any other law for the time being enforced.
I'll show you chapter wise list. I'll share the PDF also later for your benefit. I want to share so that it will be easy for you to understand
mention about
how
3 years. So
this
that's what I'm
is.
saying. Here, I'm emphasizing on this specific important things because it is a concept based. They may ask what is the imprisonment for a cognizable offense.
So
1 year, 2
criminal
year, 3
procedure
years, 4
code,
years.
you can call
They can ask.
BNSS.
So you may
chapters
get
are almost
confused.
similar in both the things. Some
Okay.
sections will be
So,
changed, but I have made it from CRPC. So
then
in
BNSS,
BNSS,
you find a table. These are the basic things. Then you get about
comparison
you
of
have charge,
CRPC and
complaint,
BNSS are given.
all those
So
definitions are
anywhere
there.
you just open that first
Offense,
couple of
all those
pages, you
things
will
are
find
there.
the
You can
comparison,
directly,
75
it is
section,
not
what is
concept,
it in
it is a
BNSS,
straight definition, what is a
77
crime,
in
what
what
is
is
an
it in
offense.
BNSS,
Because here you
77
get
of CRPC,
concept
85 of
discussions
CRPC,
only
what is
from
the so you
cognizable,
can find it in the
non-cognizable, bailable,
BNSS,
non-bailable.
where
Then
there is
someone
a
case
compare,
warrant
compare
case.
it to table is there in the
Okay.
beginning itself.
Then you have to understand what is
so
the
there are
summon, how it is
chapters
out
are
also.
similar.
Talk about
Sections
summons
are
and
changed.
Okay,
the
I
reason
now by
I gave the index of
summons
constitution
is
and I'm
normally
talking about CRPC also.
given by the
it will be easy
court
for you to
summoning a
understand.
person. Okay, to attend the court.
So it starts.
Okay, it is given in the name of the person.
Constitution of
So let us say
criminal courts and
court
officers.
wants,
I'll talk about constitution of criminal courts and
witness or a
officers today.
accused, whoever
Powers
it may
of
be,
courts, we will
to
talk about it.
appear in the
Provisions relating to
So his
administration
name is
of
Raju.
justice.
So
Okay.
court will
So
issue a
provisions
summon
relating to
Raj
Raj justice
appear in the
normally
court.
very rarely they have asked this question.
Okay.
Okay. So,
So
they may ask
summons
them
are
in advance,
issued.
but
If it is the crime is not
only
so serious,
let us say check
is
post cases,
important,
some,
even
so
some
they will ask
cheating
about
cases
the arrest
also,
of the
they issue
person.
summons only.
Okay. So
Okay. But warrant is for
then
more serious
information.
nature. Theft, murder,
chapter 5
sort
is
of
important.
thing.
Arrest
Okay.
of person.
So,
Here, powers of superior officer
in
is
warrant
not important.
cases, arrest of person
Warrant
is important.
is
Here,
issued
very important. You may expect some
to
questions.
the police.
Not to
Process
it
to
will be in the
compel
name of
appearances.
police. They will
Here,
say go and bring this
90,
person and produce in
process
the
to
court.
compel appearances.
Here
Try to
you
understand.
have
They are
summons
you
is
have
given to the
warrants
person
also,
asking him
and
to appear in the
proclamation
court.
also.
Three
Directly it is
important
given.
topics
So,
are there.
It
Where
may
you
be
need to understand the
served by court
concepts
officer.
also.
So
this is very important.
by
Chapter
any
6 is
police
very
also.
important. Mostly you will have one question from
but
chapter
warrant
6.
is served only through police.
Because you have summons in that one. You have warrant in that one. You are having proclamation. Directions to police.
So they may ask
to
any question
produce
from
the person
one of
mentioned
the
in the
three.
warrant, and they may ask even two also
to bring
from
him and
this,
produce in the
chapter
court.
6. So it is
then
chapter
direction to the
7
police to
process to compel
produce
production
the
of
person
persons
in the name.
Very
whose
rarely
name
they
is
ask.
warrant is issued.
Okay, 7
produce the person in the
reciprocal
court.
arrangements of us. No, I think they
Okay.
don't know about
So
this.
that
They
is
may not ask
very
about
important
this
when
also.
you are talking about warrant.
Earlier, I think it was
They have
summons.
made now 7
So
they
why
have
it
made
is
the
important?
new chapter
Summon
actually in
cases are
BNSS,
tried
they have
differently.
made it into
Warrant
chapter
cases
8
are
actually.
tried differently.
Okay.
There is a
Here,
small
this is
change.
CRPC. In
BNSS, they have made
trial
reciprocal
procedure.
arrangements as a chapter
Okay.
8. So summons
So
cases
you
are
have to
tried
just
faster.
remember that one. Order is almost
Okay.
similar.
Security
the
for keeping
charge sheet need not be
peace
made,
and for good
behavior
behavior
is also
formal
not so important.
mention is there.
You keep in mind.
Okay,
So
then
which are important,
even
which are
evidences
not
are also
important.
you can take written evidences.
Then
Cross-examination
order for
also
maintenance
may
of
be
wives
waived in
and
some
children.
smaller
Sometimes they must,
cases.
but
So
you
it
may
will be
ignore.
more faster
Okay.
and liberal.
Summons
you
cases.
have
So,
to. That's what I am telling. So why it is
for
important?
such
Because in
questions,
trial,
when
I am saying not
when you are into
important.
practice,
This
you
is
may
very important. Summons
questions
cases
will be asked from
it
BERAC.
will be tried
Not
faster.
from the
It will
concept.
be much simpler
Okay.
also. When I am talking of
Okay.
important,
So,
it is concepts.
warrant
is a concept. Summons
court
is a
may
concept.
give summons directly.
Session court
They
is a
may
concept.
ask them to give
evidences
in
what we used to call
Metropolitan
magistrate or judicial magistrate.
Okay,
what
until
we are
unless
calling
there
is
serious
after BNSS,
requirement, they may
magistrate
even,
is important concept.
if
So
you ask
those
insist
things
on
you
them,
have
there will
to
be cross-examination,
understand.
or else there may not be
But here,
cross-examination also. If you
other
don't want
sections,
it.
when I am saying it is not
Simple,
important, you may get questions, but you
affidavit
can
is enough.
answer those questions
But
from the
little bit
BERAC.
complicated, they may
From
cross-examine
index itself, you can answer. But in warrant cases,
Okay,
it is
maintenance
serious
of public
offences
order and
are there.
tranquility. Also, it will
trial
answer
will be
from
very
the
serious
BERAC only.
trial. Okay, so then information to police session trial is also different. You see
Okay.
again.
So,
there are three types
either
of trial.
power to
Sessions
investigate
trial
is also
warrant trial.
You can
And summons case trial. Okay. So, and summary trial is also there. Another trial is also summary trial is much simpler. Okay. So this
Just
is
hold on.
chapter 11. 1 minute. Okay. Preventive action of police. So there are some concept based things. Just you go through that one once for 149 section to 153 of CRPC and related sections in so 168 to 172 in BNSS. Okay. So I opened the CRPC also. That is the reason it took some time for me, because I'm holding BNSS book in my hand. Okay. Then
Sorry, you
information
just
to
have
police.
called, so I had to pick up the call.
Okay. You will get the compulsory question.
Okay.
So the main reason information
You got it right.
is
What is
important because
warrant case?
here it is starting from sections
differently.
154 and
Little bit difference is there.
150.
But procedure is defined in the
okay,
sessions
154
trial.
Okay. There is a chapter for
actual
section
trial,
chapter for warrant
in
trial,
criminal
there is
procedure,
chapter for
FIR,
summary trial also.
arrest,
Okay, summons case is there, warrant case is
they may go
there,
before, but
sessions
it is the
cases are also tried
main
differently.
procedure
Trial
of
before the
trial
court of
is
session
started from
uh,
154.
there is
All
a trial
earlier
of a warrant
things
case
are
by
about powers,
magistrate,
all those things.
trial of
But
summons case
real
by
court
magistrate.
practice
Warrant
starts
cases
from
and summons
chapter
cases are
12.
tried by magistrate.
Okay,
Summons
starts
cases
from
normally
chapter 12.
real court
Sessions
practices.
I'll talk
will not
about
do
that.
Okay, until and unless they come
slide.
on
I'll show
appeal.
you that.
Okay,
What
so
exactly is the trial procedure? Then
Sessions
we'll go
court
step by step for other things.
can you see all
Okay.
then session
Proceedings
cases
in
are warrant
prosecution,
cases.
this is also
Okay, warrant is issued.
see, sessions court takes only serious crime,
What,
right?
what do we say?
So,
All session cases are warrant
in
cases.
trial process.
But
Okay.
in session court, the procedure is little bit different when the trial is happening. In magistrate court, the trial is
Jurisdiction
little
is
bit
important.
different. When they are trialing,
Okay, you will
get
get
trial of
zero
warrant.
FIR
For
is
that
from
reason, they say
jurisdiction only. You
trial
got it.
before
When we are
court of
talking
session,
about,
they don't say warrant cases in case
zero
of sessions.
FIR, if you are
Okay,
aware
but
of the
they
sections,
are
you
warrant
can go
cases
and
only
search
because
in
warrant
this one,
is
but I
issued,
think
everything is issued.
nowhere
But
they
they are
mention about
normally
specific
issued
word zero FIR
in
is
the
not
beginning
used
in the magistrate court only,
BNSS.
before
not,
it is
sure about
committed to the sessions court.
But it is more of a
Okay,
concept.
arrest is made.
So
Jurisdiction
even
is removed now. You can go and give a complaint.
let us say
Jurisdiction for the courts,
other
but for the
procedures are
complaint
followed
it is
initially
different.
until
Okay.
before it is committed to
Conditions
the session.
requisite for initiation of
Then,
proceedings.
trial
This is also important.
of warrant
chapter. You will
cases
get
is
questions
done by magistrate because all
initiation of
warrant
proceedings
cases
is
start
important.
from
You may
magistrate
get compulsory question.
court only.
Summons
Then,
cases are tried by
complaints
magistrates. Again,
is
it is different as I
important.
told. That evidence procedure
concepts are
is
there.
simpler.
Then
You can give an
commencement of procedure. See,
all these things related to trial. Summary trial is
Okay,
even
the
more
charge,
faster.
the
But
trial
of warrant
now
cases,
these days
trial
they are
of summons
taking
more
cases,
time for summary,
trials.
trials also.
Okay.
Summary trial is for very small crimes.
Then
Normally,
even plea bargaining,
when even
okay.
check bounce cases, they say punishment
Plea
is up to
bargaining
2 years.
okay, I
But
didn't,
in summary
was
trials,
searching for some other
if
question
the
paper, I saw
court
that
is
question in
trying,
plea bargaining in
doing summary trial, they cannot
22
convict a
paper, I
person.
think.
If they are
Yeah,
convicting a
17.
person,
Yeah,
they cannot
AIBE
punish him
17,
for
there
more
is a
than
question from plea
3
bargaining.
months. So you try to
Okay,
answer
2
previous
months,
year
right?
questions.
Exactly,
That is
that's
also
important.
important. It is 2 to 3 months.
Okay.
Is the maximum conviction they can give in summary trial. If they are doing a
Then
summary trial,
attendance
let us
of
say check
persons,
bounds,
you can answer from index itself,
maximum punishment
and all
is up
other
to 2
things
years.
hereafter,
But
it is more
in
of
most cases,
index
because check bounce is
questions.
done
Okay.
under
So,
summary trial. So you may see
why I am giving, I will be
in
sharing
check bounce
these things
cases
to you.
STC. STC is summary trial
true.
case.
But the main
Okay.
purpose of
STC NI
index is
okay.
you will
Negotiable
understand.
instrument.
Okay.
And case number is
So,
there. STC NI number.
Then there are schedules.
So summary
also
trial
where
case,
you get
negotiable instrument, case number, whatever you call it.
there are two
So
schedules.
STC is for summary trial cases. When there is a summary trial case, the punishment will be less than 3 months only. 2 or 3 months exactly. I had to check once. Okay. So the maximum punishment is very less. And since summary trial can be done by second class magistrate also, but we don't have second class magistrate. It is done by first class magistrate as of now. Okay. So I'll now the next chapter, important chapter is Constitution of Criminal Courts. See, this is definition part. So in definition, you have those. Then there are functionaries of the court also. Police is there. Then advocates are also there. Prosecutors and defense counsels. We are defense counsel in criminal cases. Public prosecutors are also advocates, but they are prosecutors. We call them. Then defense counsels. All what we do is defense only. Then courts are part of that one. Then prison authorities also come under CRPC. All guidelines are under CRPC only. Okay. So these are the functionaries under these things. Then hierarchy of criminal courts is also important. Criminal courts are classified into Supreme Court. Supreme Court is for having all jurisdiction, but it is apex court, and mostly it is appellate jurisdiction. High Court is also appellate jurisdiction. Sessions Court is for serious crimes. Then there is a magistrate court. There are assistant session court. Okay. Then there are magistrate court. See, earlier there was in urban city Hyderabad, there was metropolitan magistrate. They have removed metropolitan magistrate since 2023 once BNSS is introduced. From BNSS, metropolitan is removed. All are now judicial magistrates only. No metropolitan magistrate is there. So hereafter it will be judicial magistrate only. Chief judicial magistrate and judicial magistrate, and there can be additional chief judicial magistrate also. So chief judicial magistrate will have some extra powers over judicial magistrate. Okay, the punishment and trial will be more powers are given to chief judicial magistrate than judicial magistrate first class. Chief judicial magistrate is also first class magistrate only, but with little bit extra power. Okay, so why hierarchy is different required? See, basically hierarchy is required because who will try the case? Who will try the warrant case? Who will try the session case? Who will try the summary case? Okay, so the jurisdiction again, courts are, the jurisdiction is on police station limits. Okay, like civil suits, civil suit is for area. I mean, let us say mandal or whatever you call, it is defined in some areas, not on police stations. But in criminal case, each, let us say 3, 4, 5 police stations are under control of one magistrate court. Okay, but when it comes to session court, normally session court, there are few specific courts are there. Subject matter courts like family court is there. Then there is juvenile courts are there. Okay, then there are POCSO courts. So CBI cases, courts, those cases that is subject matter related to courts, then they will be committed to that courts only. But normally session courts, there is no police station limits. There, if there are say 7, 8, 10 courts in Hyderabad, the court can commit to any court number 1, court 2, 3, 4, 5, whatever court, session court, it can be committed by the court, sessions court. Okay, the case can go to any court. Unlike in magistrate, it will be purely based on the police station limits. Okay, you are in Pandagutta police station, then say Nampally criminal court number 4, let us say, just I am giving a number. Additional ACJM, additional chief judicial magistrate 4. Okay, let us say if it is Paradise is not there. Let us take James Street, 10th additional chief judicial magistrate at Secunderabad. Okay, so when it comes to district, so district is different. So district, there is no separate chief judicial magistrate. It will be junior civil judge come first class magistrate. So one junior civil judge come first class magistrate. So two. So depending on that specific court, they will take you to the court in districts. But in Hyderabad, it is chief judicial magistrate courts are different, and regular civil judges courts are different in city, Hyderabad especially. But in districts, it will be both are under chief judicial magistrate or senior judge or district judge and session judge. Okay, principal senior judge and session judge, additional session judge or assistant session judge, you can have that one. So it will be, hierarchy will be given on that basis. Sessions courts cases, as I told, will be forwarded by the magistrate court only. All cases, when police will first file in their limit only, jurisdiction. Paradise police will go and file case in 10th judicial magistrate only, additional chief judicial magistrate. Then if the crime is a murder case, then it will be transferred to sessions court by the chief judicial magistrate of that particular police station limit. Okay, then it will be given to some session court in depending on the workload, all those things, it will be divided by the sessions judge. The main judge. Okay.
Sir, in a private complaint case, how we can choose a specific court, sir?
Private complaint, you go to the police station limit only.
Okay.
So where the crime is committed.
Say check bounce is a private complaint.
Private complaint, we need to give a complaint in the magistrate, no?
Yes, that's what I'm saying. Check bounce case is a private complaint. Okay, you normally don't go to police. Okay, so your bank is in, let us say, Raniganj, Secunderabad, Raniganj. I'm just specifically taking that area. I'll tell you why. Okay, Raniganj. Okay, MG Road, Raniganj. There is a police station on MG Road. Okay, but once you cross the bridge, Raniganj, there is a bridge, railway bridge is there. Once you cross the bridge, it is called MG Road only. It is called Raniganj only. But that specific will come under Metropolitan Magistrate 5. Okay, Manoranjan Court in Nampally. But before the bridge, it will come under 10th Additional Chief Judicial Magistrate in Secunderabad. Okay, same thing. When you, I know few areas specifically, so I am taking that names. When you travel from Liberty towards Narayanguda, left side road comes under Domalguda Police Station, right side road comes under Narayanguda Police Station. So left side courts come under 10th ACJM, right side road comes under 5th Metropolitan. Okay, right, same road, right side is different police station limit, left side is different police station limit. Okay, now here your bank branch is very important when you are filing the check bounce cases. Wherever you deposit the check, it doesn't make any difference. Okay, you deposit in Delhi, Mumbai, it doesn't make any difference. But where is your account? Okay, say let us say your account is in Raniganj branch. Okay, Raniganj branch of State Bank. You have to file case in police station where that branch located. Okay, if the branch location comes under Secretariat Police Station or Panjagutta Police Station or Domalguda Police Station or Narayanguda Police Station, based on that police station limit where the bank branch lies, you have to file a case in that specific court. Okay, so if it is in the Domalguda Police Station, you come and file it in Secunderabad. If it is in Narayanguda Police Station, you come and file it in Manoranjan Court. So you should be very careful to identify. You can go to the branch or you can go to the police station. You can see online maps of police station. Maps are also there online. You have to search and file. Same thing when it is a private complaint like cheating or any other thing where you want to give a private complaint. You don't want to go to police station and give the complaint. Private complaint also where the crime is committed is important. So if it is committed in the Domalguda police station limit, that's what I told. The area is defined in the map is given. What are the areas covered under Domalguda police station? What is the area covered under Secretariat police station? What is the area covered under Narayanguda police station? So if the crime is committed under Narayanguda police station, you go and give complaint in Narayanguda police station jurisdiction magistrate. Okay, if the crime is committed in the Domalguda police station, I mean your office is located in Domalguda and the cheating happened at your office, you go and file a complaint in Domalguda magistrate, I mean the police station limit, the magistrate who takes care of that police station. You got it? So private complaints are given in that way, where the crime is committed and under which police station limit it comes and which court is looking after that police station. You have to go and file the complaint in that specific magistrate. You got it?
Yes, sir.
So this is very important for advocates also. I mean, constitution of court. So you had to, for civil practice also, some say, let us say, I paid court fee last week for some, I asked my colleague junior to file court fee for what we call succession certificate. Okay. Succession certificate, somebody asked me for a succession certificate. I asked, okay, what is the property value? He told just 2 lakh rupees. So 2 lakh rupees, I was pecuniary jurisdiction. So junior civil judge, I told you just go and file this one, 2 lakhs, you pay court fee. Succession certificate is around 6%. You go and pay that 6% and file the case. So that person went and paid 12,000 rupees in the court and went and filed. They told, no, sir, we are not doing sections. The succession certificate is not, the junior civil judge is not having jurisdiction in the specific court. So you have to go to senior civil judge only. So JCJ is not having power in some courts. Some courts they are having powers. So you should be very careful. So it is now, I have to go to senior civil judge.
So my 12,000 is stuck. I had to wait till some case is there so that I can use the 12,000 rupees because I have deposited in the bank through Challan. Okay. So until unless I get some other case where I have to pay more than 12,000, I cannot use that one. They will give a certificate. I can use it in some other case if it is a civil case. But for suction, we had to deposit money separately. So I had to deposit the 12,000 separately again for this case. So that is the challenge we get when we are doing this. Jurisdiction is very important. So if you file a case in wrong court, it will be rejected. Again, you have to do the entire process second time. So you may lose face in front of your client if it is a private complaint. Okay. Police will do normally police complaint. You are not involved. You file a complaint in the police station. There is no role for you. Okay. Until unless it is a private complaint, advocates will have a role. If it is not a private complaint, if it is to police station, you are defense counsel, so you don't file any complaint or you don't file any case. You have to go and defend your client. So in this case, you don't worry about jurisdiction. Only you have to worry about private complaints, check bounce cases and private complaints. You should know what is jurisdiction. So who are doing check bounce cases, they should be very careful to identify the court and file properly, or else your case will be rejected. Okay, then you have to go and file it in the other court. It will be, of course, limitation period will be exempted if you file it in the wrong court. Limitation period is allowed because you have filed in the wrong court. So there won't be any serious challenges for limitation. So I'll share you hierarchy of courts here. Share that. Okay, this is the hierarchy of the court. Okay, Supreme Court, Final Appellate and Constitutional Authority, High Court, Supervisory, Appellate powers and revision. See, we were talking about Constitution. When you are practicing, okay, for AIBE it is different, but since here is an opportunity, I can tell you, there are a lot of provisions in Constitution where you go for appeal and other things to High Court and Supreme Court. Okay, to High Court under 226 and Supreme Court section Article 32. You go there. Okay, so it is supervisory, appellate and revisions only. You go to High Court. Sessions Court, trial for sessions, serious offences and appeals from magistrate. So once you lose in magistrate court, you go to Sessions Court. Chief Judicial Magistrate. See here, Chief Judicial Magistrate. Suresh, please mute the phone. Here, Chief Judicial Magistrate, they can give punishment up to 7 years. Okay, Judicial Magistrate first class, up to 3 years punishment. Okay, but Chief Judicial Magistrate is also magistrate of first class only. Please don't get confused. First class and above first class, what is that? So below Sessions Court, it is choose Chief Judicial Magistrate only. So, but they have given more power to Chief Judicial Magistrate where he can give punishment up to 7 years. Okay, Sessions Court give 10 years, 15 years, life imprisonment, death penalty also. Death penalty, of course, they have to get approved from High Court. Okay, any death penalty Sessions Court imposed, High Court should approve that. But Session Court can give all types of punishments. Okay, Chief Judicial Magistrate only up to 7 years punishment. If any crime is there beyond 7 years, then the case is transferred to Sessions Court. Simple. Don't IPC or BNS. If that particular case or crime where the punishment is more than 7 years, then it will be committed to Sessions Court. Okay. Here, Judicial Magistrate first class, where he can give punishment up to 3 years. Okay. If there is anything beyond 3 years and less than 7 years, he will transfer it to Chief Judicial Magistrate. And if it is beyond 7 years, that case will be transferred to Sessions Court. Okay, when the case is brought to Chief Judicial Magistrate first class, if it is more than 7 years, then he will transfer it to Sessions Court. If it is less than 7 years, but more than 3 years, Chief Judicial Magistrate, if he is there, then it will go to Chief Judicial Magistrate. Judicial Magistrate first class can only do punishments up to 3 years. And judicial magistrate second class, no, there is no judicial magistrate second class. So trials even for less than 1 year punishment also will come to first class magistrate only now. Okay, this is only for academic. If there is a question, second class magistrate, 1 year punishment is the only answer you have to remember. Okay, that is only for academic purpose. Otherwise, there is no second class magistrate in real practice. Then there are executive magistrate, like collectors are there, RDOs are there, MROs are there. So they impose fine, some maintenance jurisdiction, preventive jurisdiction, those things they take care. And police is for investigation and FIR charge sheet. There are no trial power for police. Okay, just I have given hierarchy so that who are having what jurisdiction. So police are not having any trial power. Executive magistrate are having some maintenance power where they can impose 144 sections, all those things. They will impose some preventive orders, like they even house arrest they make. Okay, executive magistrate for maintaining peace and order. So here I have given junior civil judge is equivalent to judicial magistrate first class. Okay, so whenever we are writing examination, junior civil judge exam is the JCJ is the starting examination in any states as of now. So there are no second class magistrate examinations are not there. So it is junior civil judge examinations are there. So junior civil magistrate is equal in junior civil judge is equal to junior judicial magistrate first class. Okay, senior civil judge is equivalent to assistant session judge. District judge is equivalent to session judge. These things you have to remember. Okay, district judge is session judge. Senior civil judge is assistant session judge in criminal jurisdiction. Junior civil judge is chief judicial magistrate or judicial magistrate first class. So these three are the basic categories. Okay, assistant session judge and session judge are similar category. Session judge, there is a separate examination actually. So that examination is conducted by high courts for practicing advocates who are having 7 years or plus. High courts will decide, and junior civil judges are also eligible. So most of the junior civil judges, they will appear for that examination, and practicing advocates who are having more than 7 years practice can appear for district judge examination. Okay, so senior civil judges are mostly promoted junior civil judges only. District judges and session judges are from direct recruitment or from promotions. From civil judge and senior civil judges, they become district judges. Okay, then similarly in high courts, it will be practicing advocates, and district judges, it will be the high court judges are chosen from the collegium from district judges and senior practicing advocates of high court. Okay, Supreme Court, all high court judges are eligible for Supreme Court judges. So these are the way it promoted. So you want to go for district judge also, you can start from junior civil judge, or you can write examination directly for district judge after 7 years of practice. Okay, for public prosecutor, junior civil judge, I think it is now 3 years. Public prosecutor also, I think it is 3 years of criminal practice. So this is the basic thing. Okay, all this is the powers of CJM. I'll share these things. 3 years imprisonment. I'll share this PDF. Okay, now you are clear, right?
Sir,
we'll talk about little bit more about arrest, all those things. In the I thought of doing the now only, but since already it is 8 o'clock, I have taken more time than required. Okay, so
sir,